Hello everyone, as we slowly gathering to have a taster class which will focus on investment treaty arbitration, I would like to welcome all of you joining from wherever you are joining, and I would particularly like that you do something very practical. If you are at a computer or a smartphone or a tablet, I would like you to go to www.menti.com and use the code 6336092. As the session will go on, we'll be using a couple of polling system. It could be done within Zoom, but I think this gives us perhaps a better perspective. And once you access Menti, you don't need to download anything. Once you're in menti.com and the code is 6336092, I would like you to type where do you come from. So where do you dial in from today? And that will perhaps inform a bit how the discussion will go along. If you have any questions as we go along, please feel free to intercept, and the process is that you raise your hand. You get that from the bottom of your screen, and once I see that your hand is raised, I will make sure that you are able to speak. Alternatively, of course, you can communicate any of your questions via the chat option we have. So I think it's sort of effectively about 3 minutes past the hour. And since I would like to cover quite a bit of content and give you a bit of an indication of how our classes would start, I'm inclined to start now. So the focus of this module, and Queen Mary offers 2 modules on investment treaty arbitration. Each of these modules is 30 credits, and each of these modules covers slightly different aspects of investment treaty arbitration, investment treaty disputes. So what are these investment treaty disputes? What are disputes arising out of foreign direct investment? We have had so far 1,025 investment disputes. I will often be referring them as ISDS, Investor State Dispute Settlement. The very first case we had is a case called Holiday Inn in Morocco, but the first image I have here is a highway, because this is coming from a case called Cellini in Morocco. This is the building of a highway by an Italian construction conglomerate in Morocco. It was a highway linking 2 major cities in Morocco. And in that particular case, it's interesting because the tribunal came to explain what is investment. Surprisingly enough, we do not have a full definition of what investment is, but in this case, Cellini in Morocco, the tribunal says that we need an element of different elements in order to build together that definition. One of them is that we need to have a long-term contract. So it's not a one-off contract, a sale of substantial equipment or even a sale of military equipment. So a simple sales contract or a contract which is very limited in its scope, time-wise, would not qualify as an investment. In this particular case, it was a building contract, a construction contract of the highway, but the payment of Cellini was by collecting tolls over a period of years, which was up to 20 or 25 years. So the long term is the first element of an investment contract. The second part, of course, of an investment contract is what we call the regularity of profit and return. So the money comes over a period of years, is not collected very quickly, but over a few years you collect money in order to recover your investment. There's an element of risk, because you never know whether people will use the highway, whether they will use alternative routes. There is a substantial commitment on behalf of the state. The state provides the land for the road to be built, And also we have a fifth element of this definition, which is a bit controversial, that investment contributes significantly to the host state development, so the economic development. So a long-term contract where the regularity of profit and return, where there's an element of risk, there's a substantial commitment on behalf of the state, and the contract should ideally contribute to the economic development of the state. So this is the typical investment dispute. And from what you can see in the middle of the top, the very classical investment dispute came from oil and gas. So oil exploration of natural resources is a typical long-term contract, is a concession that the state grants over a period of perhaps 20, 30, but sometimes even a longer period of time. And the recovery is a matter of sort of a long time. The third image, the water, and indeed the bottom, the waste management. So these are the modern utilities where we have classical examples of investment disputes. So water management, water purification, water desalination, supplying water and sewage services or services relating to waste management are typical of these examples. And we have cases like that all over the world. I mean, we have in Latin America, in Bolivia, in Tanzania, we have in Argentina, you have in Asia, we have indeed in Europe. And this sort of modern type of disputes of utilities where a public service is being privatized, and the private sector is paid through collecting sort of fees that the people pay, the users pay, is another typical example, and we have a lot of these cases. The rest of the case is a bit more sort of less common. TV, broadcasting license. One of the modern disputes about investment relates to the Czech Republic is two parallel cases. One is called CME and the other is called Lauder and the Czech Republic. And these are about a broadcasting license that the Czech government has given to a private TV channel operating by Roland Lauder. You might know not Lauder himself, but his mother, Esther Lauder, if you use any cosmetics created by that company, so it's a household name. But of course, Roland Lauder has a media empire, and also has created a very interesting museum in New York called Neues Museum. It's just on the side of Hyde Park, of Central Park. And in this particular case, the Czech government granted a license to this Dutch company. Lauder created a Dutch company to invest in the Czech Republic and to take advantage of the Dutch-Czech Republic bilateral investment treaty. But then when the channel, which started as an entertainment channel, started interfering with the politics in the government, or at least in the eyes of the Czech government, they tried to interfere with this investment. And they passed a decree where media companies had to be controlled to a large extent by domestic or local companies or nationals of the state. And therefore, the management of the company moved from the Dutch company to local people in the Czech Republic. They felt that it was an undue interference with the investment, and they brought two claims against the Czech Republic, once on the basis of the Dutch-Czech Republic bilateral investment treaty, the second on the basis of the US and Czech Republic BIT, and two parallel cases started. The Czech Republic won one case, lost the other case, so we had a lot of interesting issues that we'll be addressing specifically in classes about parallel proceedings, consent, the type of claims that would be brought, how damages have been calculated, what is attributed to the state, what actions are state actions. Now, the very unpleasant secret package picture, which Philip Morris, there are a number of cases involving Australia and Uruguay. The cases brought by Philip Morris against Australia and Uruguay, respectively, about legislation that was introduced in that particular government for plain packaging. As one of the measures that governments have taken to protect public health was to introduce legislation where cigarettes will have this rather boring brown sort of packaging, brown-green packaging, and a lot of sort of labels on the package, so the risks of smoking, which are true risks, so that the idea of the logo and the trademark of the company, which is associated with an ad that you might have seen on the cinema or in a magazine, where sort of a cowboy doing horseback riding, no longer should be associated with smoking. So Philip Morris initiated cases on the basis of investment treaties, arguing that the Australian and the Uruguayan governments, and indeed other governments, interfere with the trademark, with their own property, and by not allowing them to use the trademark, the sort of the product descriptor on the packages, effectively created a level of expropriation, and they should be protected by investment treaties. Of course, Philip Morris failed in both of these cases, both in the Uruguayan and the Australian case, for different reasons. In the Australian case, it became evident that Philip Morris, although it had a domestic company in Australia in order to invest in Australia, it has tried to sort of treaty shop, to try to take advantage of another treaty to bring a case against the Australian government, and therefore the case fell on jurisdiction. In the Uruguayan case, the case did not fail on jurisdiction, but failed on the basis on the fact that it is appropriate to have measures taken by a state to protect public health, and that power of the state should be considered appropriate, and therefore the state should have that regulatory power to adopt appropriate measures where necessary. Again, that's cases that we need to be discussing as we go along in a bit more detail in the future. So the final image here comes from, again, a TV series, 6 Feet Under, but the real case is a case called Lowen and the United States of America, where Lowen, a Canadian company of funeral directors, has decided to do an investment in the southern states of the United States and have a number of funeral directors. The U.S. Parties, the potential franchisees of Lowen, were hoping to invest and make quite a bit of money out of that. But Lowen, for reasons which are not necessarily known and not critical to us, decided not to continue with the investment. So the franchisees brought a class action against Lowen, asking for compensation for not having gone ahead with his investment in the southern states of the United States. And a jury trial in Mississippi awarded damages for $500 million to the franchisees. So Lowen tried to appeal that case and said there was no contract, there was no basis on which he had to pay compensation, and he did not sort of give any false expectation. He expressed his intention to do a contract, but somehow things did not go ahead. And because in order to appeal, he had to deposit the amount that was awarded plus 20%, so that became about 600 million plus in order to launch the appeal. He brought a case against the United States on the basis of NAFTA, the North American Free Trade Agreement, saying that he has been denied any justice, he doesn't have a remedy, and how is it possible to have to deposit this amount of money in order to sort of fight his case in the courts. Lowen did not succeed in this process for a number of reasons, amongst which that there was in the treaty an exhaustion of remedies provision that he did not, because he was not able to fulfill. Again, that's another interesting case that we're going to discuss, and how domestic proceedings can be the basis of an investment claim. So we've seen here a series of factual scenarios, whether it's the building of a hotel or a highway or exploration of natural resources, where public interests collide with investors' interest, and where an investment treaty, whether it's a bilateral or a multilateral investment treaty, can provide an effective remedy, so that it will allow the investor to bring a case before an arbitration tribunal and not in the domestic courts. So, as you can understand, in the current state of affairs, there's quite a bit of a debate as to whether it's legitimate to avoid going to national courts, and whether it's appropriate to have this dispute heard in a neutral forum that would be an arbitration tribunal. So, even if you're just joined now, you might not have heard the instruction, you can go to menti.com and use code 636092 and let me know what, in your view, would be your main concern about removing a dispute from a domestic court environment and take it to an international arbitration tribunal, which of course appears to be not politicized, not subject to, if you wish, to political pressures, whether that is from the press or indeed from any other sources. So would you find this type of disputes removed from domestic national court and going to arbitration to be appropriate, or do you think that's a cause for concern? So if you go to menti.com and use the code, you could let me know what, in your view, your main concern would be about ISDS cases, assuming that you do have a concern. So you have a couple of minutes to please type your responses. What would be your main concern about all of these type of cases that could be removed from a domestic court environment with everything that the court might have, and go to a private international arbitration tribunal? So you can type by going to menti.com and use the code 636092. Some people might concern that investment tribunals lack the transparency that you enjoy in a domestic court. They might lack the type of access to information that a domestic court would have, but at the same time it might be less political. Of course, in terms of transparency, it's important to note that a lot of these decisions are now published, so the transparency is not really an issue. So I note that some of your concerns are enforceability. Would an award be published? How we will deal with local law expertise? What's happening with mistakes in the award? What will happen if we need to have a correction, and how is the public interest represented? You also make the point that it is perhaps very onerous on the state to have to defend itself and pay for legal fees. In the case of Lauder, CME and Czech Republic, the legal fees came to about 20 million, and there has been a crisis in the government because it was argued that the procurement process for legal services was not entirely appropriate. And indeed, in the Philip Morris in Australia case, I think the fees went to about 35 million Australian dollars. So the cost of state defense, dealing with issues of conflict of laws, and all of that are some of your concerns. And of course, these concerns are not entirely new. These are concerns that have been around for some time. So investment arbitration operates on the basis of international treaties, and these are treaties that states have drafted, not investors. So these are either multilateral or bilateral investment treaties. For example, we have the Washington Convention setting the Center for the International Center for the Settlement of Investment Disputes, which is attached to the World Bank. We have the Energy Charter Treaty. We have in Asia Pacific region the CPTPP, which is a very important convention, which is very new. But we also have a network of some 3,300 bilateral investment treaties and free trade agreements. So investment arbitration operates very much on the basis of a treaty that states have established for the benefit of their nationals, both private persons and legal persons, that would give them the opportunity to bring a case directly in arbitration rather than go to domestic court. And in some cases, as it used to be the case, for example, for Egypt, some of this consent to arbitration was part of a national investment protection law. But also in some countries, there were a number of constitutional limitations. For example, in Turkey until 1999, it was not possible for the state to make agreements to arbitrate, but this has been lifted in 1999. In Ecuador, for example, there have been attempts to limit the ability of the state to enter into arbitration agreements in the constitution. So in this environment which has been created, the main sort of driver of most of the known disputes is ICSID, as I indicated, a part of the World Bank. And ICSID was created in 1965 because it was the beginning of decolonization. And in this period of the beginning of decolonization, a lot of the states that were living sort of the former colonies, they felt that a lot of businesses that will stay behind, they will be intimidated, they will be sort of not treated fairly, be discriminated against. So they asked the World Bank to provide good services in offering protection, and the World Bank initiated in the 1960s a treaty that was adopted in 1965, and which was creating a neutral forum for the resolution of investment disputes. The ICSID Convention itself does not provide the agreement of a state to arbitrate. It simply creates an international organization, which is the home of an arbitration institution. ICSID ultimately is an arbitration institution built on an international treaty, which entered into force in 1966, and was creating that sort of neutral international forum. So from what you can see, ICSID has 166 signatories, has a very large membership. Of course, there's a number of states that you see are not part of it. Mexico has joined with certain limitations, but Poland is not, India is not, you see Brazil is not, and of course Bolivia, Ecuador, and Venezuela were members, but they were removed. And there were a couple of states in the Indochina, which are also not part of ICSID. So there's a very substantial membership, but there are also a number of significant economies which are not part of ICSID. And ICSID will be activated only if we have a dispute which involves, from one side, an investor from a state which has signed and ratified the treaty, and on the other hand, a state which has signed and ratified the treaty. So we need the ratification for both the investors' states and the ratification of the host state that received the investment. And technically, ICSID provides a framework to assess issues of state law responsibility, a public international law responsibility of a state which might have breached certain international law protections that were provided for in the treaty. So ICSID these days accounts for nearly 800 of the 1,000 known cases, and we have 525 concluded cases and 265 cases pending. Of course, there's quite a bit of a debate as to what happened with the future of ICSID, and ICSID has initiated 2 years ago a major revision of the arbitration rules, not a revision of the convention, but the revision of the rules which organize the arbitration proceedings. And the purpose of that is to modernize and reflect modern practices from multi-party proceedings, issues of transparency, allowing for the non-disputing party participation at a much more effective fashion, and dealing with issues of arbitrators' conduct and independence and impartiality of adjudicators, dealing with issues of third-party funding, and all of these related considerations. Of course, ICSID does not only provide for arbitration, it also provides for conciliation. We should assume that conciliation and mediation, if you're more familiar with mediation, should be used interchangeably. There are no substantial differences between conciliation and mediation. Perhaps in a public international law context, we use the term conciliation more than the term mediation, because the UN Charter uses itself the word conciliation. We have had very few conciliation cases in ICSID, and some countries have used it very effectively, for example, Nigeria, but some countries almost avoid conciliation altogether. And there are good political reasons for that. I mean, it's very difficult for a state to negotiate in a completely intransparent sort of conciliation process and commit to having to, for example, pay an investor a substantial amount of money. It is easier for the state and the state treasury, in particular, to release funds if the funds are the result of a full legal process, and arbitration ultimately is a full legal process, and is a process which is subject to annulment if the process have had an issue of procedural errors or other errors that an annulment committee will identify. And ICSID has an annulment process. So these checks and balances are built into the system. And once we've got to that process, then we can move to the enforcement. And as far as we know, the majority of ICSID cases have been enforced, the absolute vast majority, because every member of ICSID undertakes to voluntarily comply with ICSID awards and to treat ICSID awards as if they were judgments of the court of final instance in their domestic system. So the ICSID jurisdiction operates on the basis of Article 25, and in our courses we'll be spending quite a bit of time discussing Article 25. Article 25 says that a tribunal under ICSID rules will have jurisdiction if the dispute relates to a legal dispute arising directly out of an investment between a contracting state and a national of another contracting state, which the parties to the dispute consent in writing to submit to the center. And I have highlighted these few words in red because although we have an element of the definition of the legal dispute arising directly out of an investment, the investor has to be from a contracting state, the host state has to be a contracting state, and you have to have consent in writing. But three of these elements are not defined in the convention. So legal dispute is not a term that the convention explains. The term investment is not a term that the convention explains, although, as I indicated earlier, in the case of Salini and Morocco, we have some sort of a definition emerging through practice, and this seems to be more or less the framework of the modern definition. And the consent is not granted through the ratification of the ICSID Convention, but you need an additional act of the state for that aspect of consent. And this additional act of the state would be either a BIT, which works together with ICSID, or a concession agreement, or an arbitration clause in an agreement between the state and the investor. And a lot of these clauses exist in various formats. We can even have that consent provided not in a BIT and not in a concession agreement, but in a domestic law, as indicated in the case that we will be discussing extensively later in the classes, called SPP and Egypt. Egypt has provided its consent not in a concession agreement, but in a domestic law, and it was the Egyptian law for the promotion of foreign investment. So the jurisdiction is actually an area where a lot of the disputes are being sort of resolved and stopped, but a few cases do move to the merits eventually. It's important to note as well that ICSID creates an autonomous regime. And when I'm saying autonomous, I mean a denationalized and a delocalized system. So when you're in an ICSID arbitration, there's no interaction whatsoever with national courts and national law. Although national law might become relevant, and Article 42 of the ICSID Convention indicates that the dispute would be decided on the basis of domestic law and international law. But you can, in the context of an ICSID case, you cannot go to a domestic court and seek their assistance for the taking of evidence, or to compel a witness to attend, or for production of documents, or for interim relief. So this is a closed system and does not interact with courts at all. There might be some interactions that haven't been tested very much, where certain aspects of enforcement could run through domestic courts, because the ICSID investment only operates for monetary, pecuniary remedies, and there perhaps an interaction there. But this is a topic that needs quite a bit of further discussion, and we will do that in classes. So ICSID is just a framework. The actual legal protection, the rights to the substantive protection, comes always from a BIT. And a BIT is a treaty between two states, is a public international law treaty, which creates binding international law obligations and also often provides for a dispute resolution mechanism, and has also the purpose of promoting foreign direct investment and protecting investment. So BITs are there to promote and protect investments. Of course, as we move forward, modern BITs have an investment facilitation element and also an investment regulation element. That's the transformation of the old BITs into the modern BITs. But you also see provisions about expropriation, the taking of property without compensation, non-discrimination, national treatment, or most favored nation treatment, which is also quite a common provision. If you see this map, I think it's quite interesting that the darker the blue, the more the BITs, and you will see that there are jurisdictions like China, Germany, Netherlands, Belgium, Turkey, Egypt, Spain, the United Kingdom, that have Argentina, the United States, which have a lot of BITs, in excess of 100 BITs, with China, Germany, and the Netherlands being perhaps the pioneers in having most of the BITs. And there are countries with very, very few BITs. And that's something that perhaps is, or with very few BITs. You see, for example, Ireland has sort of really hardly any BITs. This is because states decide to organize how they attract foreign investment in different ways. For example, Ireland for many years had a very favorable tax regime, and they felt that their tax regime would be a sufficient incentive to attract investment. And indeed, Ireland has attracted a lot of investments in the IT industry. Brazil, as you see, has also not that many BITs, but again, Brazil only started doing BITs in recent years, simply because Brazil always felt that it was a very big economy, and sort of ad hoc agreements or private agreements, not treaties, was the way to move forward. We have very good public data about BITs, and the United Nations Conference on Trade and Development, UNCTAD, has an international investment agreement navigator, or it's called Investment Policy Hub, where you have full texts of most BITs. Also, you have access to most ISDS cases with quite a bit of detail as well. Another treaty that we'll be referring to in our classes quite extensively is the Energy Charter Treaty. Now, if you look here, the green states are states which have signed and ratified the Energy Charter Treaty, and the states which are in blue are states which might have had an involvement with the treaty, but certainly did not sort of ratify it in the end. And another characteristic of these states is they often have an observer status. The light blue states do participate in the negotiations are as observers. The Energy Charter Treaty has been another driver of many, many cases. We have had more than 40 cases against Spain relating to renewable energy. We have had a similar renewable energy case against the Czech Republic and against Bulgaria and Italy. And also we have had cases against Russia, which is very interesting because one of these cases, UCOS, against Russia Federation, is the case that resulted to the highest ever award of damages, which is $50 billion US. And of course, Russia has only provisionally signed the Energy Charter Treaty, but there's a provision where even if you sign the treaty but you're not ratified, you are provisionally bound for a substantial amount of time. And Russia, but also Georgia, were sort of captured by that sort of process, and they have been involved in a number of disputes. We're also, of course, going to be discussing developments in other parts of the world, particularly in ASEAN, and also what is happening in the Pacific Rim with CPTPP. And that's a very interesting development because, of course, as you see, it doesn't capture China as such, and of course, but the United Kingdom, India, China look very much at CPTPP and look at what's the appropriate connection to have with such a treaty and how to become part of it. So, as I've indicated, there have been more than 1,000 cases. And you see that in the modern cases, a substantial number of cases are non-ICSID cases. That's the light gray. The red are ICSID cases and the other are non-ICSID cases. And we see that the growth in the number of cases is more or less proportional in ICSID and non-ICSID cases. But you also see that up to 1987, we had hardly any cases, a big up until 1993, and the cases somehow started to pick up from 1997, where the numbers became very substantial. Now, some people say that this type of cases are disproportionate and perhaps favor investors substantially over states, and effectively bring the state in a rather difficult defensive position, which is often inappropriate. I would like to offer a few more statistics here about who are the most frequent respondent states. You see, Argentina has had 62 cases against it. The two were in 2019, and the majority of cases were between 1987 and 2018. Spain has now gone to 52 cases. Venezuela has 51 cases. The Czech Republic 40. Egypt has 37, Mexico 33, and you see the list. Perhaps we should say as well that the Czech Republic has a significant record in having won most of the cases. So they have indeed prevailed in most of their cases. Egypt has also a very positive record in having negotiated successfully settlement for a lot of cases and not gone to awards. And again, countries like Ukraine have also a fairly good record in negotiating settlements or having cases partly in their favor. Now, investors predominantly come from the US, the Netherlands, the United Kingdom, Germany, or Spain. So if you see the two statistics together, Spain has 52 cases against it, but at the same time, 57 investors have brought cases against other states. So the balance is very, very interesting. And that perhaps is relevant for Turkey as well. The balance is working very good. So while countries like the US or the Netherlands are net exporters of cases, somewhere in Spain and Canada we have a bit of a balance. And there are very few cases against highly developed countries, but there are a few cases against the US. The US has not yet lost any case. There are 2 known cases against the United Kingdom. There are 3 known cases against Germany, which are pending, and they're quite acrimonious as disputes. So it's interesting also to see how these cases come, what is the outcome, and how the balance operates. You will see that in terms of percentages, 37% of cases are decided in favor of the state, 29 are decided in favor of the investor, 11% of the cases are being discontinued, and 21 are settled, and 2 find a breach but no damages. So if you look at that, one can argue that the majority of the cases ultimately go in favor of the state. Because if you put the settled and not breach, no damages cases together, so that is a 60%, and the discontinued, which because the investor perhaps has withdrawn the case, we have almost 70% going for the state in some form, either fully or in part, and only 30% in favor of the investor. If you look at in different ways, but the result of decision on the merits, you will see that some sort of in favor of the state, if we take out the jurisdictional decisions, there's a decidedly different balance there. So you need to be careful about how one reads statistics, because it's important to read statistics very carefully. So this module would then look at how these cases have been brought, how jurisdiction is being decided, and how arbitration proceedings are organized in investment disputes. And we will see that there are a significant amount of similarities between investment cases and commercial arbitration cases, but investment arbitration cases have their own peculiarities. We have international law being applicable sometimes hand in hand with domestic law, but international law has a substantial part to play. We have a significant role for non-disputing parties. We have amicus curiae briefs. we have issues of transparency, which we do not have to the same extent in commercial arbitration. And we have that a lot of the processes are actually being public. So there are circumstances where these arbitration cases run and with the participation of parties. So we have that sort of increased transparency and scrutiny, and the majority of the awards are being published. We can study them, we can analyze them. So this module will look very much on this area, and will look also at the significant criticism that is being brought by developing states and by NGOs, and how the states and international organizations respond to such criticism. And so it's a very dynamic subject, it's a very practical subject, has quite a bit of theory as well. And we see that in all sort of aspects that would facilitate your understanding the subject and take your knowledge from 0 to 100. So a lot of our students manage effectively to work directly in investment disputes as part of the employment opportunities after that. So I would like perhaps to then stop here and take some of your questions and see what are the things where some additional sort of explanations might be needed. Are there any particular questions? Perhaps reflecting a bit from where you come from, we have, India was featuring very substantially. There are, we know at least 33 cases involving India. In 25 of them, India is the respondent state, and Indian investors have brought eight cases. We've seen Brazil. Brazil has no active cases, but now has a number of BATs. I saw Colombia. There are 14 cases where Colombia is a respondent state, and one where Colombia is a Colombian investor has brought cases. So, and again, so very much a lot of these cases arise out of the Colombian-US free trade agreement, where several cases have been generated. So, going back then to this question, so how, and notwithstanding that you might not know very much, would you consider the system to be fair? And is it appropriate for a system of that type to be taken out of a domestic context and operate on the basis of an independent international arbitration regime? What is your reaction? Have you seen some of the debate in the press, and so how has this looked in your own experience? Have you been following the general discussion, particularly in relation to Philip Morris and Australia, and the debate about the power of the state to regulate, and also the power of the state to defend itself appropriately and sort of with using the right type of resources? The poll so far is quite interesting. 40% suggest that the system is fair. 50%, 45% is I do not know, and the no is actually quite limited. So it's one of these very live areas of law where there's a lot of genuine debate that we need to take forward, and we need to be addressing as we go along. So far, the results of the poll are 42, the system is fair, 8, it's not fair, and 50% do not know, which I think is a very interesting sort of dynamic. So there's a question from Katia Go, how is it to enforce the awards? The information we have so far is that the majority of the awards have been enforced. Awards in investment cases are enforced in different ways. It's not that the bailiff goes to a state and collects money. I mean, that's not typically the case. Some of the cases are being enforced by way of renegotiation. So, for example, an investor is already in the jurisdiction, claims that it has been treated unfairly and has an award in their favor. Instead of collecting on this award, they renegotiate a new agreement for longer term, and so that they can satisfy their claim in the long run. We have cases of enforcement, for example, a case called Franz Sedlmayr and Russia, where Sedlmayr was to provide security services for an international sporting event, and eventually managed to collect against Russia, not in Russia, but by using the award to enforce against Russian assets in Switzerland and in Sweden and Germany. We have a case called CMS in Argentina, where there have been some sort of the award has been sold to the bank, and the bank collected assets from Argentina in a different format. So there's a lot of enforcement, not in a traditional sense, and the general record seems to be positive that enforcement has been taking place. But of course, the question is very valid, because whenever you start any dispute, whether in court or in arbitration, the first question you should ask is whether the respondent has assets and whether you can get access to the assets if it comes to that point. So bear that always in mind. That's the first question. Are there any other questions? I don't see any hands being raised or any questions. Oh, yes, there is. So there's a question from Anna Maria, the difference between ICSID and the PCA. ICSID is this delocalized arbitration institution which was created in 1965 through the Washington Convention and is in Washington, D.C. and operates proceedings all over the world. ICSID has its own arbitration rules and a system which is entirely delocalized. So even if you have an ICSID case seated in Paris or in Singapore or in Mauritius, the local courts do not have any power over these proceedings. The PCA is a very old institution, is more than 100 years old, the Permanent Court of Arbitration. It is based in The Hague, and it shares headquarters with the International Court of Justice. The PCA is an arbitration institution with its own membership, but most investment cases under PCA are cases which run under ancestral rules. So effectively we have ad hoc arbitration with some light administration from the PCA. And if you are in a PCA cases, normally the award that will be rendered could be subject to challenge proceedings in the courts of the place where the arbitration took place. So the UCOS award that I have mentioned was in the Netherlands, and therefore the UCOS award is being challenged, and there's one final instance in the Dutch courts at the moment. So ICSID has its own annulment process. The annulment or challenge of the award does not take place in national courts. PCA is an important institution, has about 50 or 60 cases. ICSID has a much larger sort of docket, but this delocalization is perhaps the most important aspect to indicate as the difference between the two. I'm aware that the system would be shutting down very shortly, so I would like to thank you for your attention, and I would like to bring this session to an end. Thank you very much for being with me today, and I hope that I will be seeing many of you in future classes. So have a good weekend, and make sure that you and your family and your friends are safe and well in these difficult times. Have a good weekend. Thank you.